everyone. For those that don't know me, my name is Chris Walker. I'm the Vice President of the Toronto ACEDS chapter. Before we get started on today's topic, just a quick reminder that if you have not already done so, please consider being an ACEDS member and joining the Toronto chapter. Several benefits to being an ACED membership. These include access to training, different content through ACEDS, global networking opportunities, volunteer opportunities, and so much more. If you're interested at all, please feel free to reach out to anyone that is associated with the Toronto ACEDS chapter. Now on to today's topic. Our experienced panel of experts, who I'll be introducing shortly, come with a wealth of an experience, and we're going to be talking in in-depth analysis of most significant case law in and around the topic of eDiscovery. This is meant to be a free-flowing discussion. There's a number of cases that will be presented. Certainly, if participants have questions, once sort of the summary of a particular case has been discussed, happy to field those as well. I'm honored this afternoon to be joined by three individuals: Jennifer Thompson, Gordon Lee, and Michael Lalonde. Jennifer is the head of Osler Works Disputes, which houses Osler's discovery management services, along with many other innovative litigation solutions. Jennifer and her team work with all members of the litigation department at Osler's to ensure that the legal, intellectual, and practical experience of each member is captured and readily accessible by all legal professionals at Osler's. Jennifer also leads the continuous assessment and development of legal technology in the litigation department and facilitates education and training to Osler's litigators, clients, with respect to new developments in the era. Welcome, Jennifer. Gordon Lee is a lawyer at MT3, which is a division of McCarthy Tétrault. His practice covers all phases of eDiscovery and information governance, with a particular focus on leveraging legal technology for complex data analysis. Gordon advises clients on a wide range of litigation regulatory matters, including class actions, large-scale commercial litigation, and competition bureau requests. Gordon frequently provides advice on best practices for data retention, defensible disposition, legal holds, and privacy. Last but not least, Michael Lalonde. Michael is recognized as a national leader in eDiscovery by Who's Who Legal. As former eDiscovery counsel, Michael is now engaged as a senior director at FTI Consulting. Michael's main focus is on eDiscovery and digital evidence. He's authored several eDiscovery academic publications, chapters of books, and Sedona Canada principles. Michael is a member of the Digital Evidence eDiscovery Working Group, Sedona Conference, and EDRM Working Group. Welcome to all of you. Certainly a lively discussion that we'll be having this afternoon. I'm just going to bring up the slide deck, and then I'll hand it over to you, Michael, to kick things off.
Perfect. Thanks, Chris. I'll just wait for you to pull up the slide deck.
Just doing that now. Perfect. And convert it. There we are. So, Michael, over to you.
Awesome. If you could just get to the third slide, I think it is.
Sorry, the third slide?
Mm-hmm.
Sorry, which one?
The third slide, please.
Do we have some technical glitches? Because I am navigating the path forward.
Mm-hmm. It says have you shared the screen? Yeah.
Yes, I've shared the screen. I'm sorry. Can Gordon and Jennifer, are you able to see it as well, or?
Okay.
Yes, we're on the articles/publications.
Oh, Michael, you might be on mute now.
Yeah. Can you hear me now?
Yes.
Of course, Zoom crashes right when you're about to present, right?
Naturally.
If you could just go back to the third slide there. Please. Thank you. Thanks,
You're able to. Okay, perfect.
Yeah. So thank you so much, Chris. As you guys can see, 2022 was a very hustling and bustling year for eDiscovery case law. Over the next 45 minutes, Jen, Gordon, and myself are going to do our best to try and break down these exciting cases into a digestible format for everybody. On the slide deck, you'll receive, we'll have all the links to all these cases. So afterwards, you guys can go through and review through these cases in depth. Next slide, please. So this past year was also a very exciting year for a number of articles and publications that came out. First off, Sedona with their third edition came out with amazing new principles, redrafting some of the old principles and updating the case law. Secondly, there was a book drafted by Susan Wartzman and Lauren Fishman and their amazing team of contributors. The 4th edition of the eDiscovery and Information Governance in Canada came out. The Electronic Evidence in Canada binder loosely subscription also was amended with several key precedents from the DITA drafted, such as a review protocol and breach review protocol. After that, there's also an article that came out with regards to technology-assisted review and assessing privilege calls with using technology-assisted review. There was also a paper drafted by Dr. Gideon from the University of Calgary, which provides a comprehensive overview of the doctrine of spoliation. And I think that's it. The next slide, please. So we're going to go through 3 big cases first, and then we're going to go into the smaller cases. And so I'm going to turn it over now to Jennifer Thompson, who's going to go over CNOC Petroleum.
Great, thank you. CNOC was a case where one of the defendants, Sunwood Group, had sought an order confirming that certain disclosed records over which CNOC was claiming privilege were producible, and that it could rely on other relevant material that CNOC had previously produced and said now was irrelevant. Before beginning the analysis, the court reiterated that an application asking the court to inspect records and to adjudicate a contested privilege claim is a discretionary remedy, and it's to be used sparingly. CNOC claimed privilege over certain records it had previously disclosed, and it demanded the deletion of these records. So the first question before the court was whether the disputed records were indeed privileged. They articulated the principle that the party asserting the claim of privilege bears the onus of establishing the privilege. Virtually all of the records at issue were alleged to be litigation privilege. So the onus was on CNOC to prove that the documents were made specifically with existing or contemplating litigation in mind, and that the dominant purpose for the creation of the record was to assist in the litigation. The court did point out that the documents were not marked privilege, but it also explicitly said that that is not a determinative factor in establishing privilege. And it also found that they did not appear to be prepared for the predominant purpose of litigation. They reiterated the principle that underlying facts aren't privileged, even if they form the basis for privilege. And the underlying facts in a case are fair game for discovery. The court stated that the bald claims of privilege by CNOC were not supported, with the exception of one document. And as a result, the court found that the disputed documents were not privileged and had to be produced. They went on still to discuss whether privilege over the documents had been waived. In the event that privilege was established down the road, they wanted to have already made that determination. So waiver of privilege, they said, can either be express or implied or inadvertent or required by fairness. They said it was on the onus of the party invoking the privilege to establish the privilege. But once that was established, the onus, which would be a heavy one, shifts to the party claiming waiver of privilege to prove the waiver. The court held that CNOC deliberately produced the disputed records with the rest of its production. It said this disclosure was done with the involvement of CNOC external legal counsel and a document review service provider. And the court noted and relied heavily on the fact that both of those teams included lawyers that had reviewed these documents for privilege. Some of the records actually included redactions for privilege, which the court said showed that they had been assessed for privilege. The court also held that CNOC attempted to reach back in time in an effort to assert that its methodology for conducting the first review was inadequate, but again noted that many lawyers had been included on this. They stated that inadvertent disclosure amounts to waiver when knowledge and silence on the part of the party claiming privilege or reliance on that part of that person in receipt of the allegedly privileged information that was inadvertently disclosed. The promptness of attempts to recover subject documents is also highly relevant in an inadvertent waiver of privilege. And the court also considers fairness, both actual and perceived, to the opposing party and the process of the court when someone is trying to claw back privileged documents. In the particular case of CNOC, the main factor the court relied on in determining that CNOC had waived any right over the privileged documents was that the documents were disclosed to all parties in 2 productions. The disclosure was not a one-time event. The records were in the possession of the parties for approximately 15 months before CNOC even raised any claims of privilege. During the interim period, CNOC had conducted questioning of some of the defendants and witnesses, and the judge inferred that CNOC had therefore reviewed its own production in preparation for that questioning and should have detected the allegedly privileged documents. So in conclusion, CNOC did not exercise diligence in terms of advancing its privilege claim, and the court held that the privilege had been waived. In terms of relying on irrelevant documents, the court actually held that all the irrelevant and immaterial documents were in fact relevant, and they denied CNOC's request to be granted advance notice of the documents to be relied upon in this set. They said they found this suggestion troubling from a policy perspective because if permitted, it would allow CNOC to obtain a tactical advantage in the litigation, which they held was not fair. There was also an interesting point on a breach of code of conduct. In this case, CNOC had alleged that by not deleting the disputed records as soon as they claimed privilege over them, Sunwood Group was breaching the Alberta Code of Conduct. The court denied this was the case first by distinguishing all of the case law presented by CNOC. So in the other case law, the privilege had either been acknowledged or the privileged documents were stolen, or there were a very small set of privileged documents. The privileged documents CNOC was claiming over were in the range of 6,000 records. And the court did say if the receiving party is disputing the assertion of privilege, then the receiving party is not under an obligation to destroy without further review, reproduction, or any other handling or use of the document if they're disputing the assertion of privilege. So the party doesn't have to immediately delete the documents until a claim of privilege is established. And those were the main points we wanted to cover on that case.
Thanks, Jennifer. So now I'll take it over and go into Chance and Oil Gas Limited versus Yukon Energy Mines and Resources. And so in this case, Chance Oil and Gas Limited Yukon. Chance and Yukon disagreed on the scope of document discovery required for this matter. The contrasting amount of documents produced tells a story in itself, where Yukon produced 455 documents and Chance produced over 34,000 documents. Both parties took issues with the other party's affidavit of documents and broke down into 5 main issues. The first issue being that, how did the parties determine relevance? So Chance argued that the standard of relevance at the discovery stage is broader than that at trial, and that the test to determine what is relevant in document discovery is a semblance of relevance, so a possible relevance test. Yukon argued that the obligation of a party to produce documents under the rules of the court is confined to those documents that contain information relating to a material fact in dispute in the litigation, or to secondary facts leading to the proof of those material facts, as identified and defined in the parties' respective pleadings. Justice Campbell held that relevance is broadly defined and covers any document that directly or indirectly may enable a party to advance his case or her case to destroy that of an opposing party, or which may lead to a train of inquiry or disclose evidence. So in this case, both parties were actually sent back to their respective review platforms and asked to consider a broader relevance criteria, and also going to narrow down their document production. So the over and under were pushed in their opposite directions. So secondly, were the correct custodians identified? So the initial issues list that Yukon used to identify custodians of documents ignored a number of issues that were raised by Chance's statement of claim. Chance also submitted that the defective issues list had resulted in an exclusion of numerous key officials who possess relevant records as custodians. The persons who had been identified as custodians by Yukon and those individuals who were currently or at the time of the document collection holding government records included the records of former employees. Former government employees or officials are no longer custodians of government records. That was what was held. And also the government of Yukon employees who have been involved in this matter and have since moved to another position were also no longer considered custodians of relevant government records. Their successors in office or position that take over those records were considered custodians of those government records. So very, very interesting interpretation of what a custodian is, and the fact that they move around, they could actually be no longer considered a custodian. The third point were the search terms that the different respective teams drafted, were they correct? So the list of keywords or search terms that Yukon used to search its records were alleged to have been deficient and failed to include a variety of important terms and variations of important terms. Justice Campbell held that the list of keywords did not include words that were necessary to identify relevant records, and also known and commonly used variations of those words should have been included in the list. And so when drafting the search term, the parties may not have used the star or the tilde key at the end of the base words to pull up the variations of that same base word. For instance, if you search for the term wired, it's only going to bring up documents with the exact hit for that exact word. But if you put a star at the end of the word wire, you will get all the different variations such as wire, wired, wires, or wireless. So number 4 point was, were the issue codes used by Yukon too narrow? So Yukon contracted an outside consulting firm to assist with their eDiscovery aspect of the collection of the documents. And Yukon identified 7 of its employees as holders of potentially relevant records, in this case, the custodians. From there, Yukon collected 740,000 records approximately, and its custodians identified records that were potentially relevant. Duplicates were removed, and it brought the number down to about 620,000. The application lists 33 keywords, which reduced the number of documents down to 86,000. That number was further reduced to 53,000 by using continuous active learning software, so technology-assisted review. The continuous active learning technique was again used to identify the most relevant records, and through the process, approximately 16,000 records were identified as relevant. Those documents were manually reviewed for relevance by a team of lawyers based on an issue code list. The court held that the issues list was not sufficiently comprehensive to ensure that Yukon identified every document that not only would be evidence used any issue, but also which it is reasonable to suppose contained information which may or may not have either directly or indirectly enabled the party requiring the affidavit to either advance its own case. So in a brief nutshell, stuff that should have been included in the issue code list was not included in the issue code list to determine if it was relevant. And always good to know when drafting issue codes for document review, it's important to consider that opposing parties or the court may at some point have access to criticize the issue codes that you have drafted. The perfect set of issue codes for a relevance review need to consider that documents may directly or indirectly enable the party to advance their case or to damage their adversary's case. So finally, the final issue was, were the documents produced by Yukon an actual chain of emails, including a timeline, were they subject to litigation privilege? And if so, did Yukon's waiver of the privilege over these documents constitute an implied waiver of privilege over a number of other documents to which Yukon had asserted privilege, or possibly other documents? So the Yukon government produced this chain of emails and a timeline that litigation may have been claimed over. The court held that by producing these 2 documents to chance, Yukon had implicitly waived its litigation privilege, and it may have otherwise been able to claim over. And these 2 documents actually can constitute an implied waiver of privilege over a number of other documents which Yukon had asserted privilege. So this timeline that they produced with this chain of emails, they also wanted all source documents used to consult or prepare that timeline. All source documents consulted or prepared to compile that information that appeared in the chain of emails. All draft versions of the timeline. All records of communication discussing the preparation of the timeline and the summary of data referred in that chain of issues. So basically opening up this whole big box after a couple of documents were disclosed. So definitely always good to know, and always remember that when you're disclosing potentially privileged information, that could lead to a more exposure of privileged information. Now I'm going to turn it over to Gordon Lee to talk about the next case.
Thanks, Mike. Thanks, Michael. So this case, Continental Bank of Canada and Continental Currency Exchange, this is notable because this is the second Ontario case, I believe, where a stay was actually ordered as a result of one party accessing the other side's privileged information. So as background, this was litigation arising out of a failed transaction between these two parties who had intended to merge and create a new Schedule I bank. The two entities, Continental Bank of Canada was owned by a gentleman named Sprott, and Continental Currency Exchange was owned by a family called the Penfounds. So I will probably use the family names to refer to the two parties in this discussion. Before the transaction, and for some time after the transaction failed, the two parties were very intermingled. They shared the same physical location. They had a shared IT services provider. And that's ultimately what led to one side inadvertently accessing the other side's privileged information. This was not a case compared to the CNOC and the kind of, as Jen discussed, and in cases that you may see more often where one side has inadvertently disclosed it. This is one where they had direct access to it and they collected it and accessed it through that process. The first takeaway from this that I've seen mentioned in discussions of this case was when you or your clients are involved in a transaction like this, where there's a chance of it failing, you have to have clear processes in place to unwind your information. Because they didn't have this in this case, that led to the problems that occurred. And I do encourage you to read the facts because they go into much more detail about how things went wrong, but I'll give you the high level view. The ways that Penfound inadvertently accessed the Sprott information. Number one, at the time that Sprott backed out of the transaction, at one point he asked for some of the data to be backed up, some of the emails to be backed up. And again, this wasn't done with malicious intent. It was done with the hope of potentially saving this transaction and partnering with someone else at some point to continue it. And in these emails, he actually had pulled actual legal opinions about this particular litigation, and these were backed up on a USB key and all be loaded on his assistant's computer. And for some period of time, he would instruct her to run searches and to provide him with certain records that he reviewed in the course of preparing and working on this litigation. The second source where privileged information was inadvertently accessed, there was a shared network folder which was backed up to one of the Penfound Continental Currency Exchange employees that contained the Sprott privileged information. And this was collected, reviewed, and actually produced to the other side. And that's kind of where this all came to light. When they saw the other side's productions, they realized that they had access to emails where there were no Penfound employees on the chain, and they raised the question of, why do you have these emails? And a full forensic investigation was done, and that's when they discovered the extent to which they had accessed the Sprott or Continental Bank data. So once it's established that a party has access to the other side's confidential privileged information, prejudice is presumed, and the onus then rests on the party who accessed that information to rebut the presumption of prejudice. And ultimately, the judge found that there was no evidence to rebut this the presumption of prejudice, and he awarded a stay. And reading through this case, I was thinking at what point could this stay have been avoided? And like, where did things go wrong, and could they have fixed it? So number one, like I mentioned, the data wasn't cleanly segregated, and they weren't unable to unwind it, and because of that, it was inadvertently backed up and given to the other party. The next stage where things went wrong were during the review, where no one had noticed on the PenFound side that they had access to documents that they should not have had access to, namely that there are no continental currency exchange employees on these emails, and if they'd never raised the fact that why do we have these documents? And I think the facts for this case are quite sympathetic because it's because of the close relationship between the two parties. It's understandable why this would be confusing and difficult to parse out. The person collecting the data might think, I'm collecting from someone who I know is my custodian. I'm collecting from their email. I'm collecting from this folder that they have access to. I have no reason to think that contains the other side's information. To the reviewer, the parties were so interrelated that they did exchange emails between internal and external counsel, but they should have been aware of the fact, and hopefully, you would hope that your reviewers are properly trained and aware of the parties and how they relate, that perhaps they could have raised it earlier that there's an issue with accessing privileged records and made the other side aware and tried to deal with this issue at an earlier point, where they could have shown some evidence that there wasn't prejudice to the case and they did not access the highly sensitive privileged information. But ultimately, what it came down to was that the parties didn't, or the PenFound parties didn't present this evidence to rebut that presumption of prejudice. And what's interesting to note is that the judge said that affidavit evidence swearing that you do not view, you do not see the sensitive privileged information, that's not sufficient in this case. They actually required the digital forensics type. They wanted to see access logs, the actual searches that were run, and to show which documents were viewed. And had they been able to provide that, he said he could have gone down the analysis of whether those particular documents were they prejudicial to the case. But in the absence of that evidence, he had to assume that the highly sensitive, the critical documents were accessed, and that was too much of a burden to overcome. So I think that there are some issues with, could they have presented the evidence with the access logs, with the searches? That might have been sufficient to save this and to maybe not let it go to the point where a stay was the only appropriate remedy. But I think given the amount of time they had access to this privileged information, it was too difficult to unwind. I don't know if they attempted to look at the logs, but given that they had access to the other side's legal opinions on the litigation for several months, I think even over a year, where they could have potentially viewed it. I don't know if even producing the searches that were run would have been sufficient to save it, because they would have had to show that those weren't accessed. And ultimately that led to the extreme remedy of a stay being awarded. I believe this is over to Jen.
Sorry, I was muted there. So these next cases that we're going to talk about are enshrining Sedona Canada principles, which we know has been done since 2008, but we like to see them continuing to be talked about in the case law. So I'll talk about Serotech first. This was a motion to compel documentary production from the defendants and to deal with refusals and undertakings from discovery. The case was about plaintiff funds that were provided to be used on a construction project in Brazil, and these funds were used in other places. There were misrepresentations on which the plaintiff relied. in order to invest, misreps on the status of the project, the availability of approvals and the time frame and the likelihood of successful sales. So based on all of those allegations, there's clearly a lot of material information that could be collected from the defendants. So this case really reiterated several key Sedona Canada principles. In terms of proportionality, principle 2, the court said, but just because something is relevant and could be the subject of discovery or production does not mean that it necessarily or that it is commercially reasonable to pursue it. The exercise of discovery planning is intended to focus the efforts of the parties on the evidence that matters in the litigation and has as its objective to restrict and restrain the costs of discovery that may otherwise drive up the costs and delay the resolution of the action. So the court is really driving home that idea that our productions and discovery need to be proportionate to the matters at issue. They also reiterated the duty to cooperate. So that's enshrined in principle 4 by saying, unfortunately, the parties did not agree on a discovery plan and the litigation has instead proceeded with a fair degree of hostility and distrust. One might expect that between the parties themselves, given the nature of one might expect that given the allegations. Counsel, however, have an obligation to seek agreement on the procedural needs of the litigation and should attempt to approach the matter with a degree of professional detachment. So they're really driving home the principle there that counsel has a duty to cooperate with one another in order to come to a successful resolution, despite the fact that there might be very contentious matters at issue and your clients might really not be able to cooperate. Counsel has a duty to engage in that cooperative behavior. There was also interesting commentary on the use of databases and how to maintain forensic continuity in situations where the data is not, it can't be readable without software. So we come across this all the time in our practice in the eDiscovery world, where, you know, you need, like QuickBooks is a good example, where you need the actual software in order to read the data. So the court did go into some analysis on whether the appropriate action was to have someone oversee the plaintiff while they access this data. The plaintiff wanted it in raw form. It wasn't clear what they were going to do with it once they got it in raw form. The court suggested that they should actually receive printed reports that might have been relied on throughout the course of this construction. But the court didn't rule on this issue. They said the parties had to come to an agreement on this issue. So I thought that was one other interesting aspect of that case. Moving on to Merrithew, this was a wrongful dismissal case from an investment advisor at RBC. The investment advisor was seeking to amend his statement of claim, and RBC was claiming prejudice as their document retention policy is to destroy documents older than 7 years. And the claims that the investment advisor was wanting to add were over 8 years old. And the court there enshrined principle 3, which is preservation of relevant evidence, when they said, as for RBC's documentary retention policy, Mr. Gribbins does not assert in his affidavit that any relevant documents have been destroyed, and presumably RBC's policy complies with the obligation in the Sedona Canada principles to maintain a litigation hold on documents which are potentially relevant to ongoing litigation. So they said, consequently, they can amend their claim because RBC should be holding all of these documents anyways, and their 7-year document retention policy should be put on hold for relevant documentation. And then over to the next slide. This was just a really quick one. The background was misappropriation of funds held in escrow in relation to settlement and provision of legal advice. If you want to read a case about a lawyer that is quite offside, this is the one for you. It's actually pretty incredible the amount of things that this lawyer had done. But the thing that we found really relevant was when they were assessing costs on this matter, the lawyer described it as wolf packing, but I'm sure we've all seen this, where there were numerous timekeepers on a file, and people will use that as an argument to lower the cost, because the presumption is you have too many people on the file, overworking the file. But the court noted that the majority of the timekeepers were students, law clerks, and eDiscovery personnel. So it's a blessing, I see, as using these lower cost professionals to get through discovery matters, et cetera, and keep costs down. So we thought that was very relevant to an eDiscovery case law review. And those are my small cases. Passing it over.
Thanks, Jen. So these next two cases are short, and they really just reaffirm that Canadian courts approve and perhaps even expect that eDiscovery is an integral part of modern litigation. And I know I'm kind of preaching to the choir here, speaking to ACID, but to go over them quickly, I just want to note the judges actually provided us very pithy statements that capture what they were trying to convey in these cases. So those are the ones I've highlighted here, and they really sum up the messaging from these decisions. But the first one, Qingdao Top Steel Industrial and Fasteners and Fittings. This was a very short endorsement from Justice Myers, and one side had taken issue with a 17,000 document production. There were two related actions, and they asked for them to list them separately and to identify which documents were relevant to each particular action, because they thought it would be too onerous for them to go through it themselves. Justice Myers did not accept this. He said that 17,000 documents is not an extraordinarily burdensome production, given that technology abounds, and that I expect you to be able to use eDiscovery and other technology as a modern lawyer. He also found that asking the other side to go through each record was not the most efficient way to proceed, because the two actions were closely related, and the other side's evidence was, in fact, that they intended to list identical affidavit of documents for both actions. And he was of the view that if there was any question about whether some of the evidence produced did only relate to one of the actions, that could be dealt with through correspondence or through discovery questions. The second case, Leroy and Timber West, this case is kind of the latest it doesn't change the law at all, but it just kind of reaffirms that eDiscovery costs in Canada are generally recoverable, provided that they're reasonable and properly incurred in the course of litigation. And if you've read the facts, you'll know that this is actually my firm's case. And what was at issue here wasn't the reasonableness of the costs. That was unchallenged. They took issue as to whether MT3, as a wholly owned division of McCarthy Tetro, whether McCarthy should be allowed to recover those costs, or whether those should be considered part of a firm's overhead and not recoverable. The court agreed with our position in that eDiscovery costs shouldn't be considered akin to rent or utilities for a law firm and their overhead. There are costs that are incurred for the purpose of this particular case, and therefore they should be recoverable as costs for the litigation. Now, what's interesting here is they go through some of the history of Canadian case law, where the courts have held that costs are recoverable, eDiscovery costs are recoverable, and it goes back like 10 plus years. So this is kind of a long-standing case, and I noted that reasonableness wasn't challenged, but out of the three cases they cite, the Alberta case, which is PM&C Specialist Contractors and Horton CBI, that was the one case where the quantum of cost was reduced because they had not provided evidence to the court to judge reasonableness. And I think that's kind of my personal view of this, knowing kind of the background. And the takeaway is, if you are at a motion for costs and the cost of your eDiscovery expenses are at issue, make sure you provide the judge with sufficient evidence to assess reasonableness. Our affidavit really broke it down, presuming that the judge may not be familiar with typical eDiscovery terms, like why is there a cost for processing data? Why is there a cost for loading data and hosting data? We kind of explained those processes, and a lot of what's in the decision is kind of pulled directly from that affidavit we provided. So we really gave them the ammunition to say, in my view, this is reasonable and therefore it should be recovered. On to the final slide.
Thanks, Gordon. Perfect segue into T-Rex property versus Pattison Outdoor Advertising Limited Partnership, because in this specific case, there was a claim for about $13,000 in documentation expenses for a case that was conducted virtually. And there was no way of establishing how the $12,000 was accumulated post-discovery. And so they said that this was part of their eDiscovery costs, and they provided no justification or explanation about how those costs were incurred. So there was no ability to provide any sort of assessment, so costs were not awarded for those specific eDiscovery costs. So basically exactly what was held in that past case. The other case that was of very good interest was Robbins versus Kenny, where they give a shout out to the eDiscovery Implementation Committee, and the judge stated that the eDiscovery Implementation Committee, a joint effort of the Ontario Bar Association and the Advocate Society, has developed model documents, including discovery plans and an alternative form of affidavit of documents. These are collaborative efforts involving various sectors of the bar and other stakeholders who have not been the result of adversarial proceedings through the course that they are informed by jurisprudence. So just as a quick note, the EIC no longer exists. It's now been renamed into DEED, which is the Digital Evidence eDiscovery Working Group. And they have a plethora of different precedents on their website that you can click on this slide right here. And there's a variety of different things that you can see there. And that's everything from my end.
So we wanted to pause. Chris, are there any questions? And we'll give people a chance to submit.
Yeah, no, I was going to say there's no questions that have come through, but certainly happy to field any from the audience.
If there are none, we have a bonus non-Canadian case that we could cover very quickly that hope might generate some interesting discussion. So the case that we considered for this, and then ultimately cut because we wanted to keep it Canada focused, Genius Sports Technologies Limited and Soft Construct Malta. This was a competition and intellectual property case proceeding before both the High Court of England and the Wales Competition Tribunal. So in this case, Justice Smith, at a case management conference, he decided to impose a bespoke disclosure regime on the parties, deviating from what he noted was a standard approach. So before ordering, in his words, massive over-disclosure, he required the following conditions to be satisfied. He said that he's imposing this alternative regime because there's a real risk that the standard process would miss relevant documents. The massive over disclosure would not be oppressive to the parties. The risk of inadvertent disclosure of privileged materials, which seems to have come up a lot in our cases today, is contained, and confidential information is protected. So he looked at his 4 criteria and said, given his experience with competition law, he viewed that there was a risk because he found that parties will often have slightly different views as to what is relevant to a competition antitrust decision. He said the process is not oppressive to either party because they were both large experienced litigants who had access to eDiscovery tools. He said that the risk of inadvertent disclosure of privileged materials was limited in that he directed them to have the opportunity before they produced to search and to let the other side know that they had limited or had withheld certain categories of records as likely privileged. And the confidential information is protected. He said that he ordered them to limit access to primarily external counsel and experts, and to notify the other side and provide undertakings that if anyone internally at the parties accessed the database to notify what they were accessing and to give the other party a chance to contest that. So the massive over disclosure is basically said, I agree with the other side about who you're going to collect from, and then basically exclude anything that's clearly irrelevant, which is basically sort of like the denisting, removing clearly junk data, and run your privilege searches for those, and then just produce, like knowing that you can produce a lot of not relevant data, but that's how he wanted the party to sort of get on with the case. And I thought this was an interesting case because I've seen a similar process followed at sometimes for second requests in the US. But I think that's a very different context because you're producing to a regulator and not to an adversarial party. But when I mentioned this case to a colleague, she noted that she had seen another case, US case, where something similar was ordered. So like my question to the audience is, could this possibly be a trend? Do you see other judges, other jurisdictions following along? My personal opinion is I don't think so. I think even in this decision, you got the sense from Justice Smith that he was doing this because the parties weren't moving along with the standard process of discovery, and he had concerns that he did not want to have to adjourn the trial dates that were set. And he noted that if this were a case, if the parties were well along the standard process of disclosure, that he wouldn't interfere with that. And then he set up all those criteria that had to be met for this to be done. Yeah, I have questions about whether this is a faster or more efficient way to produce. I don't actually think so. To me, it seems like although you spend less time and money to produce your documents to the other side, you'll spend far more time and money reviewing and going through what's being produced to you. So it's really just shifting the cost to a different stage of the process. But I do see perhaps the appeal to a judge, namely wanting the parties to get on with it and to complete their disclosure to order something like this.
So Gordon, just as you were speaking there was two requests. So the first one I think is relatively straightforward. Are you able to share a link to that particular case that you were just speaking of?
Let me just pull that up and I'll throw that in the chat.
And I will talk through the second question as well. So, and I'm not sure if this is in relation to that last case, but there was a comment, two cases spoke to similar topics. What is relevant? One spoke to proportionality to limit relevance, and the other spoke about broad relevance to prevent reducing the data set to the point of exclusion of potentially material information. Was there any direction in either case about how to appropriately reduce for proportionality, or how broad is too broad?
So I can take that.
Okay, go ahead, Michael. I think one of those is mine.
Yeah, I was going to say Principle 2 definitely provides a lot of direction, the Stoic kind of principles. And within Principle 2, stating that in any proceeding, steps taken in the discovery process should be proportionate and take into account the nature and the scope of the litigation, the importance and complexity of the issues, the interests at stake, and the amounts that are in controversy, the relevance of the available ESI, the importance of the ESI to the court's adjudication in the given case, the cost, the burden, and the delay that the discovery of ESI may impose on the parties. And I'll turn it over to Jennifer. Hopefully I didn't take the wind out of yourself.
No, that's great. And those are all the relevant factors. I just was going to say, like, specific to my case, it was an Alberta case, and the materiality or the relevance test is different throughout different jurisdictions. So I think you'll see even proportionality amongst jurisdictions can range, and it's I always encourage our clients to, come to an agreement in a discovery plan well in advance of production on, what proportionality is going to look like, and keeping in mind those factors that Michael listed.
Great. Well, I think that answers all of the questions. I'm just checking through. Yep, answers all the questions. So I wanted to first and foremost thank Gordon, Jennifer, and Michael for joining us. Very insightful this afternoon. I think just, even based on the comments, the questions, the requests for a copy of the PowerPoint, seems that it's a very lively topic and people took a lot from it. So just on that topic of the PowerPoint, certainly once the recording is finalized, ACEDS will be making both the recording and the PowerPoint available to everyone who attended, so you will get an opportunity to have that. Thanks again to our 3 panelists. Just a quick note that in 2 weeks, February 16th, we'll be having what we're terming a companion session. And it really is sort of eDiscovery year in review in and around technology, workflows, ongoings, happenings, if I can put it that way. It really will be a technology focused discussion. Joining myself, Doug Austin from eDiscovery Today, Gretel Best, and Ian Campbell from iConnect. Certainly looking forward to that. And with that, we'll draw to a close. Thanks to everyone for attendance. And yet again, thanks again to the panelists. It was a great session. We look forward to seeing all of you soon. Thanks very much, everybody.
Thanks for having us.